Hello everyone, welcome to our next video. Which is on the Civil Procedure Code 1908, its place of suing. So in the last video I have covered till section 19. Today I am going to cover section 20. So let's see what section 20 is all about. So let us go through the Bare Act definition. So other suits to be instituted where defendants reside or cause of action arises. So the suits can be instituted where defendant is staying or the cause of action has arose. Okay. So let us read this. Subject to the limitations aforesaid, every suit shall be instituted in a court where the local limits of whose jurisdiction the defendant or each of the defendants where there are more than one at the time of commencement of suit actually and voluntarily resides or carries on business or personally works for gain. Any of the defendant where there are more than one at the commencement of a suit actually and voluntarily resides or carries on business or personally works for gain. So provided one. So that in such cases either the leave the court is given or the defendant who do not reside or carries on business or personally works for gain. As aforesaid, acquisites. So in such institution, the cause of action wholly or in part arises. So a corporation shall be deemed to carry on business at its sole or principal office or in respect of any cause of action arising at any such place where it has also a subordinate office at such place. So let us look at the breakdown of this section. So here the suit can be instituted only at the two places. Okay, so one at the cause of action as a as arised. And the other thing is like when defendants are more than one, so during that time or like at the commencement of the suit, so where the defendant is residing or carries on business or personally works for gain, the suit can be filed there. Okay. And because this is a scenario where there are like multiple defendants, so we wanted to file a suit like at a place where any of the defendant resides or works for gain. So this can be instituted with the permission of the court or the cause of action wholly or in part arises. Okay, let me explain you further and deeply into this section. So it is like a when a lawsuit which is like does not fall under the special categories which are listed in like section 16 to 19, like property suits, marriage suits, or wrong to person or movable property. Okay, so during that time then section 20 applies. Okay, this is a general rule for deciding where a suit can be filed. Okay, a suit may be filed in a court that has jurisdiction like where the defendant lives or works. Like we can file a suit when the defendant actually and voluntarily resides, the defendant carries on business, or the defendant personally works for gain at the time you file the suit. Okay, this is like a case where there are multiple defendants and each one must satisfy the conditions. Okay, so and let us see like another condition which was mentioned in the section 20, like one of the defendant lives works there. Okay, if there are like multiple defendants, what happens is like you can file a suit where any one of them resides, works, or carries on business, provided like the court gives the permission. So with that permission you can file the suit at any of the place where the defendant one of the defendant resides. Okay, the other defendants acquiesce, like meaning like they do not object because other defendants are there. Like there are five defendants, one of them is residing at like Delhi, or like other defendants are residing in some other places. So the other defendants, when the suit has been instituted in Delhi, and the other defendant should not object to it. Okay, so if one defendant lives works in the jurisdiction, the suit may be filed there with permission, like or without objections. Okay, so and one more clause in this section 20 is like where the cause of action arose. Okay, so the suit can also be filed in a place where the cause of action arises. Okay, the facts like it's give rise to the suit. Okay, it may be whole, like entire suit, or like or in a part. Okay, so this is a very important clause because like even if the defendant does not live there, you can still file the suit if some part of the cause of action occurred there. Okay, so explanation I wanted to provide is like for any corporations. Okay, so as I told you, like I was reading through the Bear Act, so I said like the corporation is considered like to carry on business in two places. Okay, one, it may be the principal office, okay, in India, or like any place where it has a subordinate office. Okay, but only if the cause of action arises there. Okay, so, yeah, if the cause of action happens in a city where the corporation has a branch office, suit can be filed there. Okay. Otherwise, only the principal office locations, the suit needs to be filed. Okay. So I would like to give examples to understand like when there is a case of like single defendant, a defendant lives and works in Mumbai, a suit can be filed in Mumbai. Okay. Suppose for an example, like I would like to give you another example where it is a case of multiple defendants. So one defendant lives in Delhi, another in Hyderabad. So you wanted to file in Delhi, like you can either the Hyderabad defendant must not object or the court must give permission. Okay, so and like let us look at the like another example. So where is like cause of action, so this is an issue. And so when the contract was signed in Kolkata but the company's office is in Chennai, so you can file the suit in Kolkata because the cause of action has been arise there. Okay, so, and I'd like to give you another example in case of like corporation. So, a bank's head office is in Mumbai, but it has a branch in Pune. So the dispute arises in a Pune branch. So, suit can be filed in Pune because cause of action arose there. Okay. So, this is all about the section 20, and let us move on to our next section. Uh, this is like section 21. Okay, so this is all about the objections to jurisdiction. So here like let us read through the section 21 as per the definition of the Bear Act. So no objection as to the place of suing shall be allowed by any appellate or revisional court unless such objection was taken in the court of first instance at the earliest possible opportunity and in all cases where issues are settled at or before such settlement and unless there has been a consequent failure of justice. No objection as to the competence of a court with reference to the pecuniary limits of its jurisdiction shall be allowed by any appellate or revisional court, unless such objection was taken in the court of first instance at the earliest possible opportunity, and in all cases where issues are settled or before such settlement, and unless there has been a consequent failure of justice. No objection as to competence of executing court with reference to the local limits of jurisdiction shall be allowed by any appellate or revisional court unless such objection was taken in executing court at the earliest possible opportunity and unless there has been a consequent failure of justice. Okay, bar on suit to set aside decree on objection as to place of suing. No suit shall lie challenging the validity of a decree passed in a former suit between the same parties or between the parties under whom they or any of them claim litigating under the same title on any ground based on the objection as to the place of suing. Explanation: the expression former suit means a suit which has been decided prior to the decision in the suit in which the validity of the decree is questioned. whether or not the previously decided suit was instituted prior to the suit in which validity of such decree is questioned. Let us see the breakdown of the section. Okay. No objection related to place of suing shall be allowed by the appellate or revisional court unless. Okay. So there should be no objection. Okay, to the place of suing. So the appellate or revisional court should not allow the objections to the place of suing. Okay, so an objection was raised at the earliest possible, so at the before filing of suit, so that objection should be raised before conducting a trial. So objection can be raised so at the earliest possible opportunity, so or before the suit issues are settled. So once the suit is filed, before conducting a trial or before finalizing the judgment that suit, the party who is like the like who's at the loss can raise an objection that's saying that the court in which the suit is filed does not have the power to conduct a trial or take up the case and give the judgment. Okay, the objection can be raised at the very beginning. It should not be raised after the suit is completed. Okay, after the suit is disposed of. Okay, and only in those cases the appellate or revisional court can take up this kind of an objections, only when it sees there was a consequent failure of justice. Okay, so the court which heard the matter does not have the jurisdiction of listening to the suit and giving the judgment. Then there is a like every power in the appellate or revisional court which can say that the decision which was given by the court was not under the purview of that court. Then it says like, see, looking at that, then it feels that there is a consequent failure of justice, so it might consider the objections which was raised. No objection related to the pecuniary jurisdiction shall be allowed. So pecuniary limit jurisdiction should not be allowed, any objection to that. No objection related to the local jurisdiction shall be allowed. So it's clearly says. Okay, so jurisdiction should be any issue about the or any objection related to the jurisdiction should be raised well before the suit was finalized. Okay, not after the suit is disposed. Okay, let me explain you in detail. So section 21, like, it is all about talks about the objection to jurisdictions. Okay, any objections related to the pecuniary, local, or like any subject matter jurisdiction should be dealt well before the suit is disposed of. Okay, so section 21 tells like when a party can raise objections about the court's jurisdiction. Okay, and when appellate or revisional courts will consider those objections. Okay, so it is very important that these rules prevent defendants from keeping quiet at trial and raising objections only at appeal to delay proceedings. So this is a very big drawback, because once the suit is finalized and disposed of, so party who is at the loss coming to the appellate court and saying the court which finalized the decision does not have any jurisdiction, so it is unnecessary delaying the court proceedings. Okay, so that is not correct. And so as per the section 21, like subsection 1, objection about like it's a place of suing, so related to the territorial jurisdiction, so an appellate or revisional court will not allow an objection because about where the suit was filed, unless it meets the conditions like objection was raised in the trial court at the earliest possible opportunity. Okay, like another condition, like if the issues were framed, the objections was must have raised before or at the time of framing issues. Condition 3, there must be a failure of justice. Okay, because of the wrong jurisdiction. So even if the suit was filed in the wrong place, the appeal court will not entertain the objection unless the defendant raised it early and showed there was a real injustice caused. Okay, during these conditions, so the appellate or revisional court can take up the appeals once they meet these conditions. Okay, and as per the section 21 subsection 2, okay, so objection about pecuniary jurisdiction. So this, like actually this deals with whether a court has a financial authority to try the case. So this should be like, this pecuniary jurisdiction should be decided well before the filing of the institution. Okay, later on the party or the advocate so should not come that the court which is hearing the case or finalize the case does not have the pecuniary limit. So at the last moment or like after deciding the case, sorry, the appellate court will consider such objection only if raised at the earliest possible option, raised at or before framing of issues. There was a failure of justice. Okay, the otherwise the objection is considered waived. Okay, so it is not going to consider the appeals. So, as per the section 21, subclause 3, objection about the local limits of executing court. So, this applies to the execution proceedings. A challenge to the executing courts, like the local territorial jurisdiction, will be entertained. Only the objection was raised at the earliest possible opportunity in the executing court. There has been a failure of justice, then only it will take up the case of appeal. Okay, if not, the objection cannot be taken at appeal. Okay, so as per the section like 21A, like it is like a bar on suits. Okay, challenging decree based on place of suing. So this section prevents parties from filing a new suit simply to say the early a decree which is invalid because the suit was filed in the wrong court. Okay, so the key rule here is like you cannot file a fresh suit to set aside an old decree based on the objection about place of suing. Okay, so you cannot freshly start another suit just because there was a decree, like because it was already been finalized, the case has already been finalized. So it is like because you can set aside an old decree because it was based on objection about place of suing. Okay, explanation: what is a former suit? A former suit means any suit decided earlier than the current one. Okay, so whether or not it was filed earlier. So even if the earlier suit was filed later but decided earlier, it still counts. Okay, so in short, like what I can tell you is like it prevents defendants from like keeping quiet during trial. Okay, and later on objecting on like objecting like and per filing an appeal about jurisdiction issues. Okay, and section 21 also prevents like it also like filing a new suit to attack an old decree. Okay, which has already been passed, so you cannot go ahead and like file a new suit. So the old decree which was passed, so it does not have any validity. So because of it does not have a territorial jurisdiction, you cannot file a new suit for that. Yeah, that will waste the court's time. So I hope you like the section 20 and 21 explanation. So uh, I think we still have some time left, so we can go ahead with the another section as well. Yeah. So let us look at the section 22. So what it says: so power to transfer suits which may be instituted in more than one court, where a suit may be instituted in any one of two or more courts and is instituted in one of the such courts. Any defendant, after notice to the other parties, may at the earliest possible opportunity, in all cases where issues are settled at or before such settlement apply to have the suit transferred to another court, and the court to which application such application is made, after considering the objections of the other parties, shall determine in which of the several courts having jurisdiction the suit shall proceed. So let us see the breakdown of the section. So power to transfer the suit which is filed in more than one court. So when the suit is filed in more than one court, so we can transfer the suit to one court where it has the power to listen to the entire suit. Okay, notice is given to the other parties to the suit. So before transferring the suit, the notice needs to be given served to the parties. Okay, before the issues are settled at the earliest possible opportunity. So yeah, so this should be done at the earliest possible opportunity. Okay, the power to transfer the suit. This should be done at the very beginning, not after like hearing the trial and all everything. We have to transfer before deciding the case. Okay, court should consider objections filed and see the jurisdiction in which court shall the suit proceed. Okay, before transferring the suit, the court should hear the objections filed and see the jurisdiction to like where in which court the suit can be heard. So it should move the suit to that particular court. Okay, so I would like to explain in detail regarding section 22. So so there is a power to transfer suits, okay, which may be instituted in more than one court. Okay, this section applies only when the nature of the case is such that the plaintiff legally could have filed the suit in two or more courts, but chooses to file it in one of them. Okay, in such cases, the defendant gets certain rights. Okay, so what as per the section 22 allows, okay, if multiple courts have jurisdiction, so A, B has a multiple courts, okay, have jurisdictions. So A and B courts have like the jurisdiction to hear that suits. Okay, the defendant may ask the transferred suit from A court to B court. Okay, where the plaintiff filed it to another court that also has jurisdiction. Okay, so the defendant may ask to transfer the suit. Okay, but this request must follow certain rules. Okay, so there are some key conditions. So under section 22, so defendant must apply at the earliest possible opportunity. So well at the beginning of the case, so the defendant may ask the court so to transfer the case to another court which has also has a jurisdiction to, and they cannot wait unnecessarily. Okay, if the issues have been framed, so the request must be made before at the time of framing issues. Okay, before framing of an issue, so the defendant may ask the court to transfer it to a different court. Okay, defendant must give notice to other parties. Okay, the defendant also should give like notify the plaintiff and any other defendants, okay, co-defendants, before applying for transfer. Okay, and application also must be made to the court that hears transfer applications. So the court in which the suit is instituted by the plaintiff should also hear that transfer applications. So like typically like high court or the district court, depending on which courts are involved. Okay, so based on that, like the application is filed in a court to transfer the suit. Okay, the court will hear objections of other parties. Okay, the plaintiff may oppose the transfer, and the court must listen to both the sides. So, the plaintiff has objected the application which is filed by the defendant to transfer the suit. So, there might be some objections. So, that court should listen the objections. Court decides which court is a proper court. Okay, court has the power to decide which court the suit needs to be transferred to. Okay, after weighing both sides, so after listening to both the sides, so court will decide which of the courts have jurisdiction is the most appropriate to proceed with the suit. Okay, The decision is final unless challenged. Okay. So the purpose of this section 22 is like the fairness to the defendant. Okay. So there is a convenience for the parties. So court may think that this might benefit to a defendant, or because there might be some challenging situation with defendant might face. That is the reason why they accept the application of the defendant to transfer the suit from one court to another court, avoiding unnecessary hardships. Okay, preventing forum shopping by plaintiffs, or like ensuring the suit proceeds in the most appropriate forum. The court decides, like it's up to the court. So in which court it has a jurisdiction, or the most appropriate court, or like the defendant has filed an application that court B is nearer to me, then so I would like to move the suit to that particular court. So I would like to give an example for this. The contract was signed in Chennai, but the contract needs to be performed in Bangalore. So suit can be legally filed in Chennai court or Bangalore court. So both the courts have the jurisdiction. Okay, they can plaintiff can file it in Chennai, and plaintiff can file the suit in Bangalore. So if the plaintiff files it in Chennai, then the defendant can say the suit should also be filed in Bangalore. So defendant is asking, so the the court saying that please transfer the case to the Bangalore, because it also has a jurisdiction to listen to the case for convenience of witness or and the documents, so which they're going to present it in the court. So they it will be a most convenient. Then then the defendant will ask for please transfer the suit to Bangalore. The court will hear the objections raised by the plaintiff or the co-defendant. Then, as per the court, it decides so which court is appropriate or to listen to the suit.